Siegel is going to be here to talk about valuation and division of government employee retirement benefits. I think many of us know how well regarded Jonathan Kramer is, and we deal with him in family court and probably in other areas of law also, and I expect that will be extremely informative. I don't know how entertaining it's going to be, but it's going to be informative. Now, this month, I think we're going to have a presentation. All I knew really when I signed up, because I signed up for what looked to me to be the entertainment value of Andy Barbin talking about colonial justice and other legal treasures. And I just know how full of information Andy is, and I figured he could no doubt share it with us in an entertaining fashion. But I didn't have a lot of other information. I did not yet have this textbook, which you all get billed for later. Because if we were going to law school, this is probably about $120 to get something like this. But I went to Andy's website, and I must say it made me feel very inadequate with my own website. And I encourage you, take a look at Andy's website. It is at www.awbpclaw.com. And one of the things he has on there is a page of hyperlinks to quotations. If you like to look at quotations by famous people, and all categories of famous people, religious people, philosophers, and there's one whole group that are historical figures. So people like George Washington in 3 different categories: what George Washington set up till 1783, what he set up to 1789, what he set up to 1799, Benjamin Franklin, Thomas Jefferson. You can see just by looking at this how much interest Andy has in history. And I'm going to introduce Andy to regale us all with his with what he knows.
Well, wait a minute, before you do that. Is this website in here somewhere? Or
on the page that has the description of the presenters at the bottom of the page, it says for more information. Okay. It shouldn't say for more information. It should say for more information than you could ever hope, want, desire, or fear to have. Because the web page has lots of links on it, and among other things, it has links to other blogs I do. And I have the materials that are in today's program are broken into 2 different blogs on a legal history blog that I'm just slowly plotting through 27 years of material to start to put together into something that other people can use. If you go into the program materials and you pass the self-aggrandizing biographies, they're always entertaining simply for how much it shows a person thinks about themselves by how much they put in them. Anyway, the program outline, I do want to go over it because I have to warn you, one of the downsides to going to a CLE that I have anything to do with is that I would not say that I follow a script very well. So even if I had a script when I came in here this morning, depending on how I look at your faces, and you're looking at a jury and you're losing them, so you have to go to something else. So, I'll follow as it goes. I do recommend, though, that a lot of times when you go to these lunch and learns, the packet of materials is just not something unless it happens to deal with forms that you need for some esoteric point of law, they usually go into the can. I wouldn't do that with this. Someday when you got time to kill and you just want to learn something, I put material in the materials that there's no way I'm going to be able to read it all to you today. And I put some of it in there as teasers, because if you're interested in any of this stuff, I have one of the world's foremost collection of esoteric legal history. All the legal classic books, I loan my books, I write down your name in a list, I have a concealed carry permit, I expect the book back eventually, but these are books that, I accumulated when William Allen Booksellers was still open in Philadelphia. And there's an old guy who, every time a book shipment came in, he looked, and he had customers that he knew, and he would pull out the book that he knew that customer would want. And so most of the legal classics I own came by that method. Now, the overview here is must-have books, articles, and journals, which I just started to talk about. Franklin at the Founding, Pennypacker's Colonial Cases, Bucks County's Contributions. I do have to make a digression here to admit that the only reason why Bucks County is in a Cumberland County Bar Association seminar is all of the cases involve my relatives. So they do involve some link to Cumberland County. Addison's resources and tales. Addison truly deserves his own seminar separately at some later date. He was one of the judges that was impeached during the Federalist Jacobin judicial purge, but Addison was a man who did not go down without a fight, and that alone is worth it. So I put some teaser materials in there today. And my primary focus today will be on James Wilson. Just by a show of hands, how many of you have seen the James Wilson historical marker that is not a block from the courthouse here? Okay, I would...
Or is it over at the old hotel?
Yeah, it's exactly. So we've kind of seen it, we've noticed it. Is anybody here a real big fan of James Wilson? You know, historical figure, kind of be able to give a quick biography of him on the spot? I was willing to bet that that was true, okay? And it's a crying shame, because James Wilson is one of the most important legal members of the Founding Fathers. He was the inspiration behind many of the principal compromises and clauses of the Constitution. And you don't have to take my word for it. You can take the word of historians. You can take the word of James Madison in his records of the Constitutional Convention. Most people don't know that. If they know anything, he signed the Declaration of Independence. Very few people know he was also a veteran and brigadier general in the Associators, which were the Pennsylvania version of the Minutemen. Everybody thinks about the Minutemen up in Massachusetts, but the fact of the matter is, long before they had Minutemen in Massachusetts, Pennsylvania had already arranged themselves in groups of associators for defense of the colony. Now, they did it under the guise of having to protect from, you know, recurrence of the French and Indian War, but the fact of the matter is, all the people involved were involved because they knew that war was coming. And those are fun facts of history that, you know, you would think a native son, the man practiced real estate law in this town. He practiced law here for an extended period of time. He was elected from here to be a delegate in not only the Constitutional Convention, but also the Constitutional Convention for Pennsylvania. And in a couple of seconds, I'm going to give you more information on how that connects to Carlisle. There was a question in the back. Can I?
Yeah. Recently, on Turner Classic Movie, they had something 1776.
Yep.
Have you seen that?
Yeah, I have.
Wasn't he?
Yeah, he's in it, but they don't give him anywhere near the role that I'm going to describe for you today. And that really is the point. We're in Carlisle. I mean, we are at the heart of Cumberland County. This is the founding father that we should be claiming as at least as important as Molly Pitcher. And it struck me how little we know about him, how little we cherish his memory. I want to, and so I will be spending most of my time today on James Wilson. I'm going to touch through, but I had a few introductory remarks because, as I said off camera earlier, I really do believe that it's important that at least once a year in our CLE programs that we have a historical program that looks back at American legal history, looks back at Roman legal history, looks back at English legal history, and it asks the questions: how did we get here? Why are we here? Should we stay here? Or is there a road higher and deeper up the mountain? And those are questions you can't ask in a program about legal techniques. But those are questions that we can take some time, maybe in the summer, when people have more leisure, ordinarily. I'm booked for 2 trials at the same time next week, but bottom line is, you know, there are important things about legal history, so I am going to bore you, before I get into the historical stories, with some quick comments that I have on the impetus for this program and hopefully others. Why legal history? The tree which is the common heritage of Western civilization is liberty under law. The common law under which we find shelter has roots extending to every corner of Europe, was successfully transplanted and crossbred with other sources when it crossed the Atlantic. we are rightly proud of our innovations. Our law has deep roots. Records confirm that Mosaic law was the predominant source for example and argument of our founders, and that Blackstone's commentaries were the predominant source of precedent well into the 1800s. Deep roots nourished and sustained the law in times of crisis and upheaval. I cannot pretend the disinterest of a historian. Detachment is not one of my vices. Freedom is never more than one generation away from extinction, and I hear the vandals at the gate. What dark age would follow if we allowed our ancient monuments to be removed, or worse, to be forgotten? I'm inherently and constitutionally conservative. To me, the proponent of a change bears a burden of proof. The greater the change, the greater the burden. I care little for the frenzied musings of the mayflies of a current season. They weigh little in the scales of collective experience. The law is a majestic, organic creation, an ancient and venerable bonsai requiring the utmost circumspection in pruning. It is a majestic vista carved with glacial excellence. To preserve and protect its future, we must guard and preserve its past. It is endangered as much from neglect as from impudent innovation. Over the past 27 years, I've collected a vast array of legal and historical materials, books, and a staggering number of articles. They all have something to tell the present. I didn't keep them at the time just because I might want to write a book on bail someday, although I might. I've got 25 articles, historical journals going back 200 years, all on the subject of bail. But that wasn't why I collected them. I collected them because at the time I was researching a case for Judge Kelly's Superior Court, and there was a bail issue, and I wanted to understand the concept of bail, not just the fact of bail and the practical utilitarian reality of bail, but to understand the precedent, you have to understand the history. And I found that as many cases as I got with Judge Kelly, whether it was eminent domain, whether it was a shared boundary line, that if you went back to the sources and then flowed forward through the stream of time, keeping in mind history and economics and other events, that the law began to make sense in a new and profoundly different way. When the law is unleashed from its moorings, its language, its structure, I mean, property law is different than any other kind of law. Why? Is there a property lawyer in this room who can tell me the fundamental reason why property law has its bizarre absolute requirements that other forms of law don't? It's real simple. Taylor, can you come here a minute? Okay. It's participatory.
There's always Pearson.
In the old days, in Roman law, if you settled a case and you were giving somebody something, you had to bring a token of that something. But in English law, in order to seize someone of property, you had to take a clod of dirt in your hand, and you had to take his hand, and you had to smack that sucker down in his hand. Because until his hand touched the dirt, he didn't own the land. And in English law, you can have a seat until the tip staff comes for you. In English law, they also had a tip staff, and he had a long pole. And when the court was calling you into the court, you were not within the jurisdiction until the tip staff touched you with the end of your staff. And if any of you are fans of the Patrick O'Brien sailing books from the 1800s, there's several scenes where Jack Aubrey is running from the courts and the tip staff is after him with the pole. And it was one of the few other, outside of Dickens, I've never actually read an accurate description of a tip staff, even though every lawyer in Pennsylvania goes and asks the tip staff when court's going to start, and I think maybe 1% of the lawyers have any idea why he's called a tip staff. Senator Hugh Scott was a good friend of my grandfather's, and it was Hugh Scott who had to go to Nixon and convince him that he had to resign. Not because he was guilty or he wasn't guilty, but because there were battles that cost too much to win. and I will give Nixon this plug in history, he made that decision twice. He made that decision when he didn't challenge the election results in 1960, and he made that decision in his resignation because of what it could do to the country. But, and Hugh Scott was the guy who could go to, Dick Nixon and say, it'll cost too much. And that was the only argument that Nixon could have heard. And there was a reason for it, and it was because whatever faults he might have had, he was an advocate. And Hugh Scott sat down at a typewriter in December 1976, and he wrote out a parting present for my uncle, Andy, who worked for him at the time. And it was in the form of a poem. And Andy passed it down to me, so I want to read it to you as the preamble to the historical discussion. I am the guide of all men, the property of no man, and the shield of the state against the lances of the evilly disposed. I am the defender of the faith of man and the rights of man. I cherish the concept of liberty within the law. I am the protector of the weak against the encroachments of the strong. I am the confidant of the distressed. I am the repositor of their inmost thoughts. I am the mediator of the disputations, composer of differences, champion of the cause of others with dignity, fidelity, and honor. I am an officer of the law and a descendant of a distinguished line. I am an advocate. Fact is not truth. Truth precedes it. Once an advocate has embraced truth in a cause, it falls to the advocate to construct a compelling story from which the truth may be encountered equally with ethos, pathos, and logos. Of the three, the most valuable and fragile is ethos, which cannot be feigned or easily regained once one glides down the gentle slope of expedience. Litigation is a full-contact competitive sport in which one could easily become lost in the bloodlust of litigation unless one captains one's ship by a constant pole star. The law is more than a profession. It is a noble calling. But to preserve its future, we must guard its past. Of course, we can't lie about its past either, because there's a reason why we make progress in the law. It's because we look back at what has been, we recognize in our current moment what can be, and with circumspection, we change what must be changed. The first item in the book, I just wanted to note that it was, in fact, William Penn who was responsible for the first printing of the Magna Carta in the United States in vernacular English. You could say that William Penn, in publishing that book, was in fact one of the principal original seed sowers for the Revolution, because it was to the Magna Carta, it was to the idea of a supreme law that rode over the whims of man that our founding fathers looked. And so the publication in the United States of the Magna Carta in the 1600s is a fairly important fact. I gave you both pages of that, including the little broadsheet. I preferred in the color, but the broadsheet of the original publication. After that in the materials, you'll see that I have attempted to collect in very brief fashion some of the great lights of Anglo-American law. And I think you have to start with Sir Edward Coke, Knight Edward Coke. And he was the late Lord Chief Justice of England. And what's important, and the point that I wanted to make with this particular set of commentaries, is if you are going to get any of these original sources, if you're going to go back and you've decided that the phrase "strive mightily, eat and drink as friends," okay, that was not Shakespeare, that was Lord Coke. And the bottom line is, if you're going to go back to original sources, I would do a little research, because there's always one edition of a particular set that is far better than another. And I will give you 3 quick examples. If you have Lord Coke, you want the Ireland abridgment. It is historical in its own right. And his comments reflect very accurately the temper of that particular day, and in that respect are as entertaining as the book itself. The second example I would give you is, and I did give you a page that gives you a kind of their view of the different editions of the book. The next one, I don't know if any of you practiced before the Superior Court in the 80s. Anybody here going to acknowledge? Is there any particular judge that the picture of Blackstone brings to your mind? Just look at it. Is there any particular judge that you might say bore a strange resemblance?
Speed?
And no, we get no takers on that. But I want to flip to Blackstone's Commentaries. If you were a lawyer in colonial America and you owned a book other than the Bible, there is no question that you owned a copy of Blackstone's Commentaries. Because if you had a copy of Blackstone's Commentaries, it was the equivalent of owning the entire West Digest series. Because it contained all the case law that anybody was going to know about in the colonies. And so most lawyers at that time rode circuit. They had a horse, and there was a saddlebag on either side of the horse. And he might have more than one set of saddlebags, but you could bet volume 1 and 2 were in saddlebag number 1, and volume 3 and 4 were in saddlebag number 2, because that's how you tried law. One of the other interesting things about colonial law was because they were riding circuit, you've got these hotels, and there's one where Abraham Lincoln rode circuit. And they've restored the hotel, and they've done a big history of it. So if you put in riding circuit and Abraham Lincoln in a search term, you can pull up some pretty good articles that describe this process of the litigants, the judges, and the attorneys all sitting down to get to dinner together every night. And I have to tell you, I couldn't imagine. I mean, I invite my opposing counsel to have lunch with me, or, and most of them decline politely, but every once in a while you get a solid citizen and you can stride mightily and eat and drink as friends. But I'm having a hard time thinking of, some of the cases I've had, if the judge, the litigants, and the lawyers were required to sit at the same bench table, share the same communal stew pot. I mean, that's an image that really, I think, is worth remembering when we're considering our civility obligations. How much greater were they then? How much greater was the need for civility? And when we think about the speeches in Congress and they begin, the honorable gentleman from the state of disillusionment, insanity, whatever state they happen to be from, they still say it so politely. And that is one of the that's like a vestigial tale of historic civility. And I think our profession would do well to sort of regrow some of those niceties that too often we've forgotten. After, I want to note that in the Blackstone's edition, if you're a Pennsylvania lawyer, the gold standard for finding the volume that you want is the George Sharswood edition, and it was printed in 1872. And the reason why it's a great edition is because it's 75 years from the beginning of Pennsylvania. And so what Sharswood did in his notes was he collected the first 75 years of law in Pennsylvania as the United States Pennsylvania, as opposed to a colony. And the citations are all from the original reports, the Rawl reports, the whole series of Pennsylvania reporters before they started numbering them 1, 2, 3, and 4. With regard to his comments, he's also very much like Oliver Wendell Holmes was with Kent's Commentaries. Kent was the first who put together a truly American set of commentaries that became a benchmark, but the Oliver Wendell Holmes edition of Kent's Commentaries is the one you want to own if you're going to own one, because Holmes's notes are at least as important as Kent's commentary. And a lot of the law that Oliver Wendell Holmes brought much later in his Supreme Court decisions had been presaged in all those early notes. And it's of, you know, so if you like Holmes, it's of some particular interest. A lot of people don't give credit, and since my associate has Italian heritage, I thought I would be remiss if I didn't note that there is one other book that is uniformly identified as being at the heart of the Founding Fathers' understanding of law, justice, and where positive reform would go, and that would be the Marquee Beccaria of Milan's commentary on Crimes and Punishment. And again, the Voltaire edition might be a good one to try. Okay, there's an English translation of the Voltaire edition, and so you get Beccaria and Voltaire for the same price. What's not to love about that? In this particular case, I'm not going to read these particular ones out loud, but I gave a couple of pages of the translation where there were interesting ways of putting things that sound awfully modern to me. But the one that I'm going to read is The Secret Accusations, and I love this. You know, think Star Chamber, think, you know, writing out writs of evidence and not being able to confront the witness, which was the reality. Before 1776, it was the reality almost uniformly. And what Beccaria had written about it was, secret accusations are a manifest abuse, but consecrated by custom in many nations, where from the weakness of government they are necessary. I thought that was an interesting statement, that the secret accusations arose not from the power of a government, but from the weakness of government. And I think that it resonates true today. But how prescient, how insightful then, because this is before the revolution. Whoever suspects another to be an informer beholds him an enemy, and from thence mankind are accustomed to disguise their real sentiments, and from habit of concealing them from others, they at last hide them from themselves. How many generations of history are summed up in just those sentences written before our founding, but quoted repeatedly by our founders? The next article I just want to touch on lightly, I already mentioned in the context of stability. If anyone is interested after having read the 10 pages of the, I think 6 or 10 pages of the article that I printed out, in the whole article, you know, send me an email. I have it on PDF. I'll send you the whole article. But the gist of the article is that one of the problems when you have a revolution, you know, there are some inconveniences, like your entire court system grinds to a screeching halt because the people who used to have offices think they still do. And the people who think they just got new offices have to convince other people that they ought to respect those offices. Now keep in mind, Pennsylvania had a double problem in that Pennsylvania had to be one of the most Tory-ridden states in the United States at the time.